Ladies and gentlemen, may I have your attention, please? Thank you. It's great to hear such lively conversation. When it's hard to silence a room, it's a sign that people are very engaged. Always a good sign. I'm Michael Pack. I'm the president of the Claremont Institute. I've been president for about a year and a half. Thank you. I think most of you know about the Claremont Institute, but I've had some questions, so let me at least tell you a little bit, even if most of you know. Our mission is to restore the principles of the American founding to their rightful and preeminent place in American life. Clearly, a mission I think more important today than ever before, when those principles are under attack from all sides. We have three principal programs that do that. There's the John Eastman's CCJ, which you all know, which is one of the hosts of the evening. And as you know, they do amicus briefs and litigation to defend constitutional principles. We have a book review, the Claremont Review of Books, that comes out quarterly and publishes weekly on its website. I encourage you all to subscribe and go to the website, which can be gotten from our own website, from claremont.org. And finally, we have fellowship programs where we bring people to Newport Beach and try to teach them in a week or two the principles of the founding. We have some graduates of the fellowship program in the audience. Thank you. Actually, maybe those people, why don't they stand, those that have gone through the fellowship program. Thank you all. They're a great group, and so these people are representative of about 400 or so graduates that are in all walks of life: media, government, think tanks. And we have three programs: one for recent college graduates, the Publius program; one for people in mid-career, the Lincoln program, people in their late 30s and 40s. There's at least one Lincoln graduate in the audience. And finally, the one that's run by John Eastman and CCJ, the Marshall Fellowships for people who are recently graduated from law school or are going to or have just finished clerking for a judge. And it's a very distinguished group. It's our youngest of those programs, but in its, I think, 5 years, it's had many distinguished graduates, clerks for Supreme Court judges, and for judges like our honoree tonight. So it's a great institution. I'm really proud to be its president. Let me thank the sponsors of today's event. Without sponsors, we, the Claremont Institute, could do nothing. So we never tire of sponsoring them. Our event co-sponsor is the Federalist Society. Thank you. The reception sponsor is the Bush firm, Tim Bush's firm. Thank you to them. The keynote address sponsor is Larry and Margie Smith. Thank you to them. They're here. Our panelist sponsors are the Heritage Foundation. Thank you. Michael T. Anderson and the Private Trust Management Group. And Robert Lowen. Other sponsors of today's events include Richard Christie. Thank you. And Ed Laird. Thank you to him as well. I'd also like to thank the Claremont Institute staff that put the event together. That would be Christine Domenech, Ileana Serafian, Kristen Wolgamuth, Ann Basonic, Carolyn Buffone, and their entire staff. And thank you very much to all of them. It's a very complex event to put together with the panels and lunch and a lot of moving parts, and they've done a great job. Finally, I want to ask John Eastman to come up and give our award out. Thank you.
Thank you, Michael. It's my distinct pleasure to get to introduce Judge Alice Batchelder. I want to tell you a little bit about this award, though. We call it our Reagan Jurisprudence Award. We launched it, decade and a half ago. We don't give it out every year. We're kind of stingy in who we give it to. The idea there is to recognize a person who has through their careers, exemplified the advancement and the return toward constitutionalism in our jurisprudence. The first recipient of the award was then California Justice and now Judge on the D.C. Circuit Court of Appeals, Janice Rogers Brown. We also gave it to Ed Meese because Ed Meese, more than anybody else and almost single-handedly, launched the revival of originalism as a viable constitutional interpretation mode. We've given it to Judge Bill Clark, who was an unsung hero in the Reagan administration, with his hands behind the scene on almost every success that President Reagan had through much of the career. Other than the great president himself, probably more responsible for the end of the Cold War without firing a shot than anybody else, but also very significantly responsible for this revival of the notion that the rule of law and the Constitution is what guides our judiciary and our elected officials every day. So I'm delighted to add to that august list today Judge Alice Batchelder. Now, I got to tell you a little bit about her history. She was nominated by Ronald Reagan to serve as a district judge in the Northern District of Ohio. And I just want to show you how this fight over originalism has changed the confirmation process by way of her own career. She was nominated on February 28th and got her confirmation by the Senate just a month later on April 3rd. 1 month to get from nomination to confirmation. Less than a decade later, things had gotten a little more controversial, and she was nominated by George H.W. Bush, whose conference room we're in right now, in June of 1991, and it was almost 6 months before she got confirmed in that spot. And then in 2005, there was a retirement by Justice O'Connor, and she was considered to be on the list, the short list for that appointment. I suspect that would have been more of a battle royale by that point. For the very reasons we're honoring her today, there was a news account done at the time by ABC critical of her. She's a constitutionalist and a rigorous practitioner of judicial restraint. But despite that illegitimate strictness, she wears sweatshirts and jeans to work. Now, she herself said that applying the limits of the Constitution shouldn't be Republican or Democrat. It should be the duty of every judge who has taken an oath to uphold and defend that precious document. And I think that's exactly what the role of the judge is. She exemplifies that quite well. Our own founder of the Claremont Institute and its first president, Peter Schramm, before he passed away, and then for many years the executive director of the Ashbrook Center in Ohio, said that she's a consistent and conservative, has a consistent and conservative judicial philosophy that she's manifested from the bench. She's gotten involved in some controversial cases over her time, upholding Ohio's partial birth abortion ban, saying that manufacturers of guns are not responsible for what the people subsequently do after a gun sale, disputing the notion that we ought to have race-based admissions at the University of Michigan, claiming that it was not unconstitutional to have a small poster of a Ten Commandments in a state courtroom. I love that one most importantly because when the Supreme Court considers those cases, they do so under a marble frieze of Moses. Now, the official word of the guides in the Supreme Court these days is that Decalogue that Moses is holding in his hand, in that frieze above the bench of the court, the 1 through 10 actually represents our Bill of Rights, not the Ten Commandments. So I once asked the guide, is it the official position of the United States government that Moses handed down our Bill of Rights? But my favorite set of cases that she's done on her time on the bench have involved the Commerce Clause. And you heard about the limits on federal power and the loss of those limits when we've manipulated the language of the Commerce Clause. In two cases, extraordinary cases, United States versus Chesney and United States versus Farsi, she kind of recognized when the Congress is given the power to regulate commerce among the states, that actually means it's got to be commerce and it has to be interstate. And if you're missing one or the other of those, you don't get the power to regulate. And it's, it's radical. The ABC thought this was radical. But here's what she said about it. She says, The framers of our Constitution drafted the Interstate Commerce Clause, not the Interstate Clause. The majority's construction renders the commerce component meaningless. Such a reading violates the intent of the framers and transforms the Commerce Clause, a measure drafted to prevent state interference in the economic affairs of the nation, into a virtually limitless federal power. And then to bolster her argument, and I'll close with this because this is so fun. To bolster her argument, she relies on Thomas Jefferson and the Kentucky resolutions. It's not very often we see a federal judge doing that these days. And so we are honored and pleased to have Judge Alice Batchelder today to both give this talk to us and to be the recipient of our 2016 Reagan Jurisprudence Award.
I guess I should start by saying you can see how far I got with my view of the Commerce Clause. It's really difficult for me to express how honored I am to be here today and to receive this award. When John Eastman left a message for me a couple months ago to call him, I had absolutely no clue what he wanted. So I called him, and when he told me, I admit I probably sounded a little like Miss Piggy, because I think I remember saying, "What?" Why? Which he really didn't say much about. But I am really thrilled and very humbled to accept this award. It's hard to conceive of a higher award than one bearing Ronald Reagan's name. He's extremely important in our household, and thank you. Of course, a few weeks later, John called and said, well, I would have to give a speech. I said, well, okay. And then just a few days ago, I learned that I would be following the likes of the Johns from this morning. Not an easy thing to do. But this is a day of scholarly attention, I think, to the principle of separation of powers. And I don't pretend to be a scholar. I've been really good at rounding up extremely scholarly law clerks over the years. But I'm not a scholar, and my husband once told me that judges are really sort of legal plumbers. Of course, he's a legislator, so. But we always had our own version of separation of powers at our house. I always knew that if I blurred the lines between the judicial and the legislative, and if I blurred the lines between the federal and the state authorities, I would come home and find the locks had been changed. Inside our home, I really would have been delighted to observe separation of powers, but we only had the judicial and the legislative represented, and there had to be an executive, and I was pretty much it because Bill was gone a lot of the time. And I would throw this in light of one of the musings on the panel this morning, many of the musings about the horrible overreach of the bureaucracy. When we have two kids, and when they were very young, they were, I think, about 8 and 5, we were in Washington, and we were driving down past one of the big, huge buildings, and our daughter, who was the younger of the two, said, Daddy, you promised you would show us a bureaucrat. And we were stopped at a light, and Bill said, oh, I did, Lil, that's right. Well, you see that guy in the gray suit coming across? That's a bureaucrat. And Elizabeth said, but Daddy, he looks just like everybody else. And Bill said, and that's why he is so dangerous. Anyway, I'm not going to try to compete on the scholarly level of the program thus far. I'm just going to make a few observations about how the principle of separation of powers looks from my side of the bench. And I will try to be brief. My daughter, who is a lawyer but has no intention whatever of ever practicing law and is at home raising and homeschooling her children, said to me, "Make it short, Mom. I'd always rather leave feeling cheated than bludgeoned." A long time ago, many, many years ago, I was appointed to serve on the Constitutional Law Drafting Committee of the Multi-State Bar Exam. And after a few years on the committee, which consisted of 3 professors and 2 lowly practitioners, I innocently inquired at one of our meetings why we never seemed to be developing any questions that involved separation of powers. And the very cavalier professorial response to that was, well, you know, whatever that once meant, and despite a few aberrations like, you know, Chadha and Boucher, it's really pretty much a dead letter. Well, I was not a scholar even then or now, but I'd have to say that didn't sit very well with me. And several years later, by that time I was on the Court of Appeals, I found myself preparing for oral argument in a case that I believed was simply flat out a separation of powers case. However, my Harvard undergrad, Chicago law degree law clerk did not think so, and was busy explaining to me how wrong I was. But I stuck to my guns, and we had some very good arguments. And one day he came into my office and he said, "I've been doing a lot of research on this, Judge, and I've concluded that you're right." I said, "Well, even a blind pig finds an acorn once in a while." So let's get an opinion drafted and see if we can get somebody else to go along with us. And we did. I got one of the other 2 judges to go along with me, although his arm was kind of, behind him by the time we were done. And over a very strong dissent from the 3rd judge, we published the opinion and held that the statute at issue violated the principle of separation of powers and was unconstitutional. And the then chief judge of our circuit immediately demanded en banc review. And he didn't even bother to send around an explanation, as we're required in our circuit to do, of why he thought there should be en banc review. He simply scrawled in felt-tip pen across the bottom of the form that we use, "The authoring judge clearly does not understand the law." Well, that was subtle. But he didn't get a majority of the court to en banc it, and so I kind of forgot about it. And many months later, one morning, I discovered that, in fact, I had been affirmed 7-2. In that case, that was Plout versus Spendthrift Farms. Thank you. I was elated, and so I showed my secretary the response that I thought I ought to send, just the note that I would send to the judge who had demanded the en banc review, and it would have looked like this. My secretary was much more mature than I, and so she prevailed, and I didn't send it, and to this day, I'm sorry that I didn't. And I would also say that within a couple of hours of my learning that I had been affirmed, I also learned that the federal building in Oklahoma City had been bombed. And so I won't ever forget the day for either of those reasons, I suspect. And I was able to crow a little bit at the next con law meeting, committee meeting. Now, I know that this is a Constitution Day observance, so what I'm going to say next may seem a little incongruous, but I used to routinely accept invitations to speak to the law school chapters of the Federalist Society, and my topic was usually the anti-federalists and how they have been proven largely correct. And I always concentrated on their view, and particularly Brutus's view of the judiciary, and how the federal judiciary would both usurp the power of the federal legislature by interpreting the Constitution and the laws according to, as he put it, their reason and spirit. In other words, what the judges preferred that they said rather than what they actually said, and would effect, as he said, an entire subversion of the legislative, executive, and judicial powers of the individual states. Well, particularly with regard to the reason and spirit, what the judges would prefer that laws and the Constitution said. I won't name the justice of our current United States Supreme Court, but one of them, in a speech that I attended, I'd never met him, and I still haven't, one of them said this, and I wrote it down on the only paper I had, which was a little slip from the gas pump that I had stopped at to fill up my tank on the way, because it was all I had by way of paper. He said, every judge on any level, no matter the case, always has to ask himself the square one questions. And the square one questions are, is it fair? Is it just? Is it decent? Is it right? Does it comport with the law and the Constitution? The minute he was through speaking, I grabbed my law clerk and said, we're out of here. And my law clerk said, don't you want to go meet the justice? I said, no, not now, not ever. Because what he just said was, I'm in charge of policy. And we're not. And Brutus said that would happen. And that is, however, even though I won't name him, the same justice who also said, and I point this out because of one of the topics that was covered this morning, who also said that morality cannot be the basis for our laws. Well, in my speeches to the Federalists, I used to point to one case as a perfect example of how the judiciary would usurp and Brutus thought destroy the constitutional setup. The case that I like to point to is Missouri v. Jenkins, which was either 1990 or 1991, and I did just notice that the National Review, the bench memos, just celebrated the anniversary of this case, and I just want to point out that I was doing this a long time before National Review pointed it out. But in that decision, the Supreme Court reviewed the federal district court's order that imposed a tax on the school district in order to fund a hugely expensive and expansive capital improvements program and curriculum expansion that the judge was requiring as part of his desegregation order for the schools. And it went to the Supreme Court, and the Supreme Court said, it is accepted by all the parties, as it was by the courts below, that the imposition of a tax increase by a federal court was an extraordinary event. In assuming for itself the fundamental and delicate power of taxation, the district court not only intruded on local authority, but circumvented it altogether. Well, the court having said that, you might expect that the court would have gone on to say that this delicate and fundamental power is not and never has been a power of the judiciary on any level of government in the United States. But in fact, what the court went on to say was, before taking such a drastic step, the district court was obliged to assure itself that no permissible alternative would have accomplished the required task. Well, the justice I have not named earlier wrote a terrific dissent in that case and pointed out that the Constitution of Missouri, which was the state at issue, prohibited the school board from levying taxes in that amount without a vote of the electorate, that there was absolutely nothing unconstitutional about the Missouri Constitution that thus restricted the taxing power, and that the power to tax is not and never has been a power of the judiciary. And here, I would say, not only was the judiciary arrogating to itself the power to tax, it was doing so at the expense of the authority of both the state and the local governments, and maybe more fundamentally, due process. Anyway, it's always been a fundamental principle in our system of government that the power to tax is in the hands of the electorate, either directly or through their elected representatives. The dissenting justice acknowledged the importance of enforcing the guarantee of equal educational opportunity for our nation's children, but he said, we're not in the business of balancing one fundamental right against another, and that the end could not justify the means used here to accomplish it. Now, Missouri v. Jenkins has not been expanded as of yet. I wouldn't want to bet on it, but clearly, neither has the court ever said that it was repudiating the clear suggestion in that case that the power to tax was there in the judiciary, It just doesn't seem to have really come up again. But the threat to the sovereignty of the states from that case, in my view, is unmistakable. I mean, we fought a revolution over who can impose taxes in this country. And even the most revisionist history books don't suggest that the answer to that question is the federal judiciary. That case, in my view, does not blur the separation between the powers of the federal government and the state governments. It erases it. And what that case also involved, and this is of particular importance to the federal district and appellate courts, is the idea which the Supreme Court did not address in the case, that it's just fine for the federal courts to take over state and local institutions and run them if they don't like the way they're being run, which is, of course, another eradication of the separation of federal and state powers. Of course, the federal courts have been doing that for decades, but there, in my judgment, is no constitutional justification for that whatsoever. So a few years ago, when I was appointed to serve as one of 3 judges on what is, under our system, a district court panel, but it consists of at least 1 appellate judge and 2 district court judges, to decide a constitutional challenge to the way a county jail was being run, I was squarely up against the question. Because after hearing evidence and a bunch of expert opinion, we all agreed that the way this jail was being run did violate the Constitution in a number of respects. So the question was, what are we going to do about it? And I listened to my colleagues, both of whom were very, very fine judges, and both of whom I respected hugely, or in today's parlance, I guess, hugely. And they were discussing the way we were going to fix this problem and how we were going to implement the remedies. And I suggested that if that was the approach we were going to take, I would have to dissent, because although I conceded that I thought we had the raw power to run the jail, I didn't think we had any authority to run the jail. That what we had the authority to do was to rule that the jail was not being constitutionally run and the county couldn't continue to run it that way. So they could fix it, or we could shut it down, but we could not run it. And the other 2 looked at me for a minute, and then one of them said, "You know what? You're right." You know, it's another blind pig moment. It was great. And it was a sort of a small victory for separation of powers, but an important one. And I suppose besides that, do I look like someone who would want to run a county jail? Well, we routinely, as judges, run into the separation, from my side of the bench, of course, run into the separation principle and the resistance to it in a lot of quarters in the area of habeas corpus. Before the Anti-Terrorism and Effective Death Penalty Act, better known as AEDPA, it was Hornbook law that the federal courts reviewed state criminal judgments only for constitutional error. It was also Hornbook law that was routinely honored in the breach. In fact, I will never forget my early naive days as a circuit judge. I sat on a habeas case, and one of the members of the panel was bent on granting habeas relief. It was a capital case because of errors of state law. And I said to him, but we can't overturn a state judgment because of errors of state law. We can only review for constitutional error. And he said, state court judges can't be trusted to make these judgments. Well, he started out as one. So we should trust him now? Anyway, after AEDPA, that same judge continued to take that same approach, as I'm afraid have a number of my colleagues on the Sixth Circuit. If you look on Google, which is easier to find this on than Westlaw, you'll find some real gems from the Supreme Court reversing my circuit, even summarily reversing, saying, for example, because it is not clear that the Ohio Supreme Court erred at all, much less erred so transparently that no fair-minded jurist could agree with that court's decision, the Sixth Circuit's judgment must be reversed. Or, another time, the Sixth Circuit's decision was a textbook example of what the Anti-Terrorism and Effective Death Penalty Act proscribes, using federal habeas corpus review as a vehicle to second-guess the reasonable decisions of state courts. Well, I think that these cases sort of implicate the principle of separation of powers on two levels. First, of course, the federal courts are required to defer, and after a couple of the more recent federal Supreme Court habeas decisions, notably Harrington v. Richter, we have to doubly defer to the findings of the state courts. And secondly, it's the prerogative of Congress to spell out the law governing federal habeas corpus. And the federal courts are required to apply that law and not to substitute their own judgment for that of Congress. And we fight about this routinely in my circuit. Regarding the latter aspect of separation of powers, the Supreme Court said, again, reversing my circuit, this standard we recently reminded the Sixth Circuit is difficult to meet, by which I think they meant Congress intended that the habeas petitioner would have a steep uphill climb, and the circuit courts are not here to provide the cable car. So my erstwhile colleagues on the con law drafting committee, I spent 32 years there, and I finally said, you know what? Enough is probably enough. They could use some fresh blood, so I don't do that anymore. But their view, to the contrary, notwithstanding, separation of powers is, at least in the realm of habeas, alive and well. That's the good news. The bad news is that it's so frustrating to be on a panel where two of the judges just aren't going to be confined by the requirements of AEDPA. On the other hand, I think there's probably some more good news. When the Supreme Court has been reviewing these cases, I've been on the winning side of virtually every single one of them. And I would very briefly mention one more area where separation of powers impacts us regularly as judges, and that is the area of statutory construction. After King v. Burwell, established by the state actually means established by the state or the federal government. How exactly are we supposed to go about the task of statutory construction? Reliance, I'm quoting now, reliance on context and structure in statutory interpretation is a subtle business, calling for great wariness lest what professes to be mere rendering becomes creation and attempted interpretation of legislation becomes legislation itself. Chief Justice John Roberts in King v. Burwell. But apparently that reliance is okay if to instead read the statute to mean what it says means that Congress screwed up and the statute won't do what the court thinks Congress intended. Then, of course, you engage in the creation and you legislate. It's frustrating because we confront that routinely. Many years ago, remember all the uproar over civil RICO and the Supreme Court's decision in the Sedema v. Imrex? The court in that case said, it is true that private civil actions under the statute are being brought almost solely against respected and legitimate enterprises rather than against the archetypal, intimidating mobster. Yet this defect, if defect it is inherent in the statute as written, and its correction must lie with Congress. It is not for the judiciary to eliminate the private action in situations where Congress has provided it simply because plaintiffs are not taking advantage of it in its more difficult applications. In other words, screwed up statutes must be fixed by Congress, not the courts. And that was the rule for construing statutes for a long, long time. But it's kind of hard to say whether that's going to continue to be the rule. If King stands for a very expanded view, then we're all going to have to figure out how we go about interpreting statutes. And one I would just mention is a small piece of Dodd-Frank, which we were talking about this morning, but there's a circuit split right now over what the definition of whistleblower in Dodd-Frank means. The language could not be clearer, but if you look at the whole context, you can create an ambiguity. So the Second Circuit says it's expansive. The Fifth Circuit says, no, it's not. It says what it means, and that's how it should be interpreted. And trust me, this is a very live issue right now. So last week, one of my departing law clerks gave me a really nice hand-painted, ready for framing picture of the first part of the very familiar exchange between Alice and Humpty Dumpty. When I use a word, Humpty Dumpty said in a rather scornful tone, it means just what I choose it to mean, neither more nor less. The question is, said Alice, whether you can make words mean so many different things. She was well named. The question is, said Humpty Dumpty, which is to be master? That's all. But that segment, it's not in my painting, that segment goes on to include Humpty Dumpty's wonderful statement that when I make a word do a lot of work like that, I always pay it extra. Well, I gotta tell you, I am wondering how much the Supreme Court paid the word state when it decided King v. Burwell. Or, for that matter, how much did it pay interpret? Do I still have a couple minutes? Well, this morning's program has been absolutely marvelous. And the topic couldn't be more serious. And I'm not kidding when I say that we do run up against this very, very regularly, and it gets very, very frustrating. And so, and my law clerks all say that I'm pretty much Eeyore in the way I view things, and it's true, I am. Although for those of you who are fans of C.S. Lewis, one of my law clerks says I'm simply Puddle Glum, and I think that's probably true too. But I thought maybe I would leave you on a somewhat lighter note of other things which we do encounter. And this comes from my days on the district court. I was about to take a change of plea from a guy who had been indicted for tax fraud. He had a little business which he called Mr. Income Tax. Would you go to Mr. Income Tax to have? Probably you wouldn't. Anyway, so he had been indicted for tax fraud, and he's before me to change his plea. And so, you know, the court reporters there, I'm ready to go through the whole dog and pony show, and I realized that he's just tugging on the sleeve of his lawyer. And so I stopped, and I said, do you need to have a chance to talk to your lawyer about something before we proceed? Oh, no, Your Honor, but see, I'm diabetic, and I took my meds this morning, but I'm feeling sort of, and I said, we will take a break, and we will start back up when you are ready to do so. So I went back in my office, and I said, take a couple of those ginger cookies I made last night and brought in for you guys out there to this guy, and let's get his sugar content up a little bit and see if we can get this show on the road. So we did that, and after a bit, I was advised that he was ready to start. So I went out there, and I said, now, are you feeling well enough to proceed? He said, well, I am, Your Honor, but see, my wife is sitting in the back of the courtroom, and she wants to know, did you make those cookies? Because if you did, she'd really like to have the recipe. It's all on the record. It is. Well, I didn't give it to him. Instead, I took his plea, and a little later, I sentenced him. And the day after I sentenced him, I got this letter from him. Now, it was on his official stationery of Mr. Income Tax. I always like to show you that so you won't think I'm making this up. The letter says, Your Honor, spelled wrong. Yesterday, I was in your court for sentencing. I received a 2-year sentence. On the way back from Cleveland, my wife, my mother, my sister, and I hardly said 10 words. We were so shocked at what you gave me. Your Honor, I was expecting a suspended sentence with probation. Your Honor, I wanted to tell you what was the greatest thing that ever happened to me in my life is woman. She conceived me, grew me in her womb, went into labor, gave me birth, nursed me, cleansed me, raised me to the age of 6, brought me to school, introduced me to another woman. That woman introduced me to all the other women that gave me the education that I have today. When I became 15, I came to know the pleasure and comfort that a woman can give. From that time, I went out and sowed my wild oats. I then found one I wanted to marry. She gave me comfort, pleasure, cooked my food, and cleaned my home. She also laid her life on the table 3 times, giving birth to our 2 children, and I nearly lost her in a very bad miscarriage. That, to me, is woman, the greatest thing that ever happened to me. Your Honor, I do not want to go to prison. Please, if you can suspend any or all of the sentence that you gave me, I will appreciate you for the rest of my life. Your Honor, I run a nursing home for the mentally ill. I receive no pay, and if I go to prison, my poor wife, Martha, will have to take over and not know what she is doing. She is filled with arthritis, does not drive a car, and has no one to help her. Our daughter is expecting a baby boy any day now and can't help. So you see, I need your help. Please suspend my sentence. Thank you for being such a nice lady and an honorable judge." Well, I did not respond to the letter. I did not suspend his sentence. And many months later, I got another letter. Now, this one is not on his stationery. Your Honor, still spelled wrong. Today is 225 days, 7 months, 15 days of being incarcerated here in prison. When you sentenced me to 2 years, I was very upset with you for doing that. But after being here, I think about it. You saved my life. Outside on the streets, I was a walking dead man. My weight was out of control at 296 pounds. My blood sugar was 327 points. I've lost over 50 pounds, and my sugar count is down to 100. You have saved my life by at least 10, maybe 15 years, whatever God may will. I know I've done wrong, but there are always 3 sides to every story. My side, the other side, and the side that no one ever hears. Well, I'm not going to tell you that side because maybe you will think it's only trying to pull the wool over your eyes, and that I would never do. And then he proceeded for about 2 pages to try to pull the wool over my eyes. And he said at the end, "But I'm not going to try to blame my ex-son-in-law for what was done in my case. I should have had my eyes open, but I was too lazy to do that. But I now know that all I want to do is get out, be with my wife and family, and I don't want to be with my wife for sex because after 40 years of marriage, there's more to it than sex. We now sleep in different rooms." Well, yeah, he's in prison. She's at home. My dog Freckles sleeps with me. My wife is my company and friend, the mother of my children and the grandmother of our grandchildren. All I want to do is make things easy for her, and I can't do that here. If there's anything you could do to reduce my sentence to time served, please work it out with my attorney. And he thoughtfully gives me his phone number. And whatever you can do for me will be greatly and honestly appreciated. I need your help. Thank you for taking the time to read this letter. You're a wonderful lady and doing your job, and a good job at that. And if I ever get out, I will never be in court again or in trouble, so help me God. But what I don't have, because I can't find it, is the letter I got a couple days after that from Martha. She was not urging me to reduce his sentence, and Freckles sleeps with her now. Thank you more than I can say for this wonderful honor.
Well, I hope you can all see why we think she was deserving of our Jurisprudence Award this year. Among her law clerks have been 5 former Claremont Institute fellows. Judge Batchelder is tied for first in the record of the largest number of Marshall fellows. You got to work on that, I know. Diarmuid and Edith are trying to catch up to you.
Do interns count?
I don't know. We'll have to figure that out. That's a question of judicial interpretation. Anyway, with that, we'll be back at 1:45 over in the back in 237A. Now, let me just describe. When you go downstairs to the first floor, out the back of the building, if you turn right, you will run into Freedom Plaza, which has a piece of the Berlin Wall in a reflecting pool. Overlooking that symbol of tyranny is a replica of the chair in which Abraham Lincoln sits in the Lincoln Memorial, the symbol of freedom. And surrounded it on the benches where you can sit and contemplate the whole scene are various great quotations of statesmen through the years about the importance of freedom and liberty. So that's Liberty Plaza. If you turn left outside the building is where you will you'll see a big circle of flags, our International Plaza, and on the walkway down toward International Plaza is where most of the busts that I talked about earlier. So enjoy a few minutes of time leisurely looking through those parts of the campus, and then be back ready for our forced march this afternoon at 1:45. Thank you all very much.